We hope that you enjoy yourself today, tomorrow, and that you take home with you an increased breadth of knowledge on the various topics that will be covered. This panel today will cover in detail the role of the governing board at institutions of higher ed and the relationship between the governing board and an institution's administration, faculty, staff, and sometimes, most importantly, students. We'll cover disciplinary and investigative authority of the governing board, the requirements of the open meetings law, the open records law, generally speaking, open government law. Any questions that you may have, and that's always a hot topic, please feel free. The requirements of conflicts of interest law will also be covered, and other laws relating to public officials. And finally, we'll be dealing with a lot of ethics issues and ethics policies adopted by institutions of higher ed, as well as by the Texas Ethics Commission. And we'll cover the government code provisions and others that deal with those areas of interest. To assist in presenting all of this material today, let me introduce the two gentlemen to my left. The first person to my left is Kabi Caputo. He's a lawyer who provides general counsel services to independent school districts and community colleges in Texas. He's also a litigator. He represents schools and colleges in constitutional claims, Title VII claims, Title IX lawsuits, and other civil rights litigation. Mr. Caputo advises boards on a wide array of legal issues, including policy development, open government issues, student discipline, student and employee rights, personnel, special education, purchasing, and finally, construction. He serves as outside general counsel to Austin Community College and several Texas school districts, and performs special project work for Alamo colleges, among others. The gentleman to his left is Fernando Gomez. Fernando is the Vice Chancellor and General Counsel of the Texas State University System. Fernando has held that position for a total of some 25 years, and during that period he's authored 3 books. He's consulted and lectured on higher education and legal topics throughout the United States and overseas. Fernando also covers the same types of law that I mentioned concerning Mr. Caputo. And in December 2011, some 4 years ago almost, Dr. Gomez published a Texas State of Mind, which was the voluminous text commemorating the Texas State University system and its various colleges and universities in celebration of that system's centennial year. Please join me in welcoming Kabi Caputo and Fernando Gomez. Kicking off the presentation will be Kabi Caputo, and will be Fernando Gomez. Okay. And Fernando is going to cover ethics, conflicts of interest, governance, and related issues. And again, if you have questions, you can either hold them until the end, or if you prefer, you can ask it at the point in time where the question arises. We can deal with it either way. Feel free to do either. Fernando, all yours.
Okay. Thank you, General Counsel Franz.
You know what's going to happen, so.
I can be trained.
I was very nervous one time that I went with our chancellor was invited to the Lieutenant Governor's conference room or room that he has in the Capitol to attend a dinner. And I went and I put my name tag on upside down. This is Mr. Dewhurst. And he comes over and he says, Fernando, he says, you got your name tag on upside down. And I said about the silliest thing, first thing that came through my mind was, well, Governor, I knew I was going to be nervous in meeting you, and I wanted to make sure I could read my name so that I wouldn't forget it. He kind of stuck his tongue against his cheek. He says, okay, okay. It is such a pleasure, Chairman Jenkins and regents and trustees, to be here with you. Let me begin with a story. You're entitled to a story. Years ago, when I was about to graduate from law school, I'd been married about a year to my wife, and she had a grandmother who spoke only Spanish, although I know she understood English, and the grandmother came on the day of my graduation. The family was having a party for myself and for my brother-in-law, who was graduating high school. And lady, very religious Catholic lady, came and brought an envelope, and she handed us each an envelope. And he opened the envelope, and it was a holy card inside of a greeting card written in Spanish, both of them written in Spanish, and a nice note saying how proud she was and signing her initials. She always signed with her initials, AUR, Aurelio Olivari Romero. Now, this is a lady that had raised a family of 5 daughters in rural area after her husband died when she was 36 years old. But she had no money. She was bringing in $89.23 a month in Social Security and living with my mother-in-law and father-in-law. But anyway, inside the card was a 20 and a 5. And of course, my brother-in-law got the same gift. I got the same gift as my brother-in-law. I was a new in-law, but she gave me the same gift. But when I finished law school 3 years later, went home, and she comes up with a card, and there's a big smile on her face, and she says in Spanish how proud she is of me, and I want, no, Grandma, no, I don't need this, please, no, and she presses it into my hand. And I open it up, and there was a holy card in Spanish, and the greeting card in Spanish, and the note with the initials, and a 20 and a 5. And when I graduated got my PhD several years later, 4 years later, we're home for the holidays, and she comes up to me, and she's a little wisp of a woman, 4'10", very slender, and she's got her hand on her on her hip, and she's tapping her foot on the floor, and she's waving this thing, and she says, ¿Cuántas veces más vas a graduar tú? How many more times are you going to graduate? And so I said, Grandma, abuelita, es la última vez, the last time ya recibí mi doctorado. I received my doctorate. He says, ¿Eres doctor? Sí, abuelita, soy doctor. ¿Sabes que tengo un dolor aquí? She could never figure out what the heck a PhD was for. Anyway, but it reminds me, it's strangely related to ethics, because so much of what we do in ethics is really unenforceable. Although the state of Texas has tried to make an ethics code that has some force of law, and we're very fortunate for that. But so much as it's doing the right thing. It's not the legal thing. It's not, but it's the right thing. And but she was doing as she thought the right thing, and treating me the same as she treated her own grandson. Now, you have in your materials an excerpt from Texas Education Code, Chapter 51, and this deals with the responsibilities of governing boards and system administrations and institutions of higher education. Now, as far as the board is concerned, there are generally 3 imperatives. And what this law says is that it is the policy of the state that governing boards of institutions of higher education, being composed of lay members, shall exercise the traditional and time-honored role for such boards as that has evolved in the United States and constitutes the keystone of the governance structure of each governing board. This is the most important thing that I can ever tell you about being a regent or trustee. And it's probably one of the most difficult things that you will ever have to do in that role. The first imperative that the legislature has laid out is that the board is expected, and this term is in there, is expected to preserve institutional independence and to defend its right to manage its own affairs through chosen administrators and employees. Administrators and employees chosen to the board, by the board. That's the essence of trustee. That is why you were appointed by the governor with the advice and consent of the Senate. You are at law officers of the state who are removable only through impeachment. Now, I understand that we have community college trustees here that become trustees as elected officials, and the same principles with respect to impeachment apply to them. But the point is that you exercise that judgment as a board. You are given plenary authority over the campuses over which you have stewardship, and we'll talk about this later, but if anybody from the outside calls, whether it's the Speaker of the House or the Lieutenant Governor, the Governor, doesn't matter, says, you know, I'd like for you to do X, Y, Z. You listen and you're polite and you be respectful, but you also have that duty as a board to make the decisions that you consider collectively to be in the best interest of the institution. So that's the main imperative, preserving institutional independence. The second one is that you have traditional duties, and those traditional duties involve essentially establishing goals, naming the chancellor or president, naming and assisting the president, creating an atmosphere in which these individuals can prosper and advance the interests of the institution. You also have an imperative to make clear to the coordinating board position, the universities or the system's position on important matters. Finally, the third imperative is a fiduciary relationship over the handling of money. And nothing in this law delegates or authorizes the delegation to any outside person of this regental or trusteeship authority. There is a law also that talks about the responsibilities of system administrations. Very briefly, it's to assist and advance the interests and the needs of the various campuses over which they have authority delegated through the board. This includes helping with long-range planning, providing technical assistance, including legal and financial, evaluating and assisting with performance goals, and performing board-assigned duties. That's what the administration does of a system. As far as the institutions, now this is the really high-sounding and really the highest goals of these institutions. Transmit culture, extend knowledge, teach and train for the professions, promote research, protect intellectual exploration and academic freedom, strive for intellectual excellence, provide post-secondary education training, and provide continuing education. So in this construct, this three-part construct, we've got the board at a policy level, providing general guidance and oversight and assistance. We have system administration as a facilitator, not necessarily a regulator, although I know sometimes there are aspects of regulation that the board may choose to impose through its rulemaking processes. And then finally, the highest, the noblest goal of higher education is the advancement of human knowledge. Let me pause a moment here. You have a handout in your materials that is called Duties and Ethics of Public Sector Board Members under Texas Law. And this is, I'm a great one for symmetry. I love symmetry. This has 4 major categories, four points under each category that I think lays out, first of all, the general authority and duties of board members. Secondly, conduct at board meetings. Thirdly, conflicts of interest, which we will talk about in a little bit. That's generally Donna Cornell's area. And finally, relationships with the chancellor's staff and presidents. As you approach being a regent or a trustee, let me suggest to you that there would be 3 questions that I think you want to ask yourselves. What do I have to offer to the institution? What in terms of my knowledge, in terms of my experience, relationships that I may have in the legislature, in private sector, throughout. And then why do I want to serve? And finally, where can I best contribute? These are all decisions you should be thinking about and questions you should be thinking about. Notice what's missing here. What's missing is how can this help me? This is public service is not for everyone. And if the approach is how can I profit now or in the future, it's the wrong reason for public service. We have people, many of you have excelled beyond belief in the professions, in business, and these are the reasons why the governor and why these institutions are so pleased to have you as regents and trustees, because you have something substantive to offer. I've talked about independence. Let me talk about the general authority and duties. 1 is the duty of loyalty. 2, the duty of unity. 3, the duties of the chair. And 4 is the authority of committees, board committees. The duty of loyalty, the regent or trustee must first of all be loyal to the institution. We have had regents appointed who have not been graduates of the institution or who have been graduates of the institution. And it's a difficult thing, and I have seen some marvelous, marvelous examples in our centennial book that Bill mentioned, where somebody was a graduate of an institution but handled his or her relationship with the system in ways that were even-handed and impartial. In a multi-system institution. There is no other constituency. It's not the governor that you must please or serve. It's not, and I recognize as a trustee, a community college trustees, that you do have constituents because you are elected, but the primary responsibility ought to be to the institution. I believe it was said at the time 4 years ago or several years ago when Jerry Sandusky at Penn State and Joe Paterno had their difficulties that what went wrong there, according to the report that the board had commissioned, was that what had gone wrong is that the loyalties had switched not to Penn State, but to Paterno. And I'm not criticizing the man, but I'm saying, and people have said, well, this is likely to happen again. Well, maybe the specific event is unlikely to happen again, but you know what? You build relationships with your presidents. You build relationships within the board. But that loyalty has got to run again to the institution, not to the man or the woman that's running it. And that's an easy thing to slide on. I have heard, not this board, I want to be very clear, and maybe not necessarily in higher education. I've heard people say, well, and have been part years ago of a situation where the chancellor left and there was not a great split, it was a small split on the board. One or two regents remained loyal to him. And it's okay to have that sense of affinity, but at the end of the day, you have to place that loyalty with the institution. We lost in that process one institution. And I don't want to say much more about that for obvious reasons. The point I want to make is that as you work with people, whether it's a chancellor, whether it's a president, the affinity, the relationship, and the loyalty has got to run to the institution. There's a duty of unity. No single member of the board may speak or otherwise bind the board unless authorized to do so by a majority of the board, pursuant to an action taken in open or public session. And Kabi is going to talk to you about this in just a little bit, but you are one voice as members of the board. Thirdly, the duties of the chair the chair may speak and represent the board under a general grant of authority, but may not take positions he or she knows contrary to board policy. So you represent the board, you provide leadership, and in between board meetings, you have interactions with the chancellor or the president. And that's a proper role for a chairman. Also to make sure that the meeting moves along efficiently and thoughtfully, and that everybody sitting at that table has at least the opportunity to speak or express opinions. And that's a very difficult thing sometimes, I think, for people to do, but it's not about your chairmanship, it's about your leadership, and can you help others rise above themselves in serving that board. The committee authority, generally the committees have the authority to report and recommend policy to the board. It's infeasible and costly, and you would never get folks such as yourselves working with these boards if you had to participate in every little aspect of the board's business. So you have your finance committee, your academic affairs committee, and you work through those committees, and another opportunity for people to provide leadership. As far as the conduct at board meetings, everybody has a right to speak, to state his or her views, opinions, positions, and the chair has got to facilitate that expression of opinion. There's a duty to listen respectfully. It's not personal. Somebody takes a view that you disagree with. It's not about you. It's about the other person's right to express a point of view. There is a duty, I believe, to respect board decisions and not to undermine them. That's the democratic process. Now, I may end up on the short end of a vote, but that doesn't mean that you go and you try to sabotage the policy decision that the board just made. There is a law in Texas. It's in Government Code 651.003, and what that says is that any board member in this state has a right to state a dissenting opinion and to have it put into the minutes of the board, and the chairman has to see to that if it comes to that point. I can share with you, because it happened so long ago in the 80s, where the board fired a president, and it was a very contentious split vote, 5-4. And as counsel, I was being asked by the 4 what to do to sue the 5. Now, I get 4 people angry at you. Get 4 people angry at you for very easily. The only thing worse is getting 5 angry at you. But you have to say, this is the decision. This is the decision of the board. I think you need to talk with your with those whose opinion you value. You need to talk with the chairman, and you need to come to some resolution with this. And but the decision is made. Okay. There's a duty of confidentiality. There's a lot of things I'll tell you in executive session that are for you. If it's legal advice, or we're negotiating some kind of a business deal, or we're receiving a gift from somebody or a donor, or it's a personnel decision, if you don't respect the confidentiality of that executive session, you've not served your board well. That doesn't mean you can't talk about it. I wouldn't talk about it to my law partner. I don't even talk about it to my wife, to be honest with you. That's something that can only be released through the order of a district court of this state. And so there is sanctity in that, and the reason for that is to protect you and to protect the decisions you made. It's not uncommon for regents to get sued. It is very uncommon for regents or trustees, I think, to get sued individually. But it's not uncommon to get sued. But the easiest way to end up in jeopardy in a lawsuit is to disclose what was said in executive session. I'm going to skip over for the moment the conflicts of interest section. I think we'll talk about that later on. I would tell you basically 3 rules, and this is all I'll say. 1, if you have a conflict, disclose it. Disclose the conflict. 2nd rule, record the disclosure. Do so in open session. Say what it is, disclose, record it, have it recorded. And 3, recuse yourself from participation. I would note that the Texas State University System Board of Regents goes a step further, and they require the individual with a conflict to leave the room so that nobody can say that somebody made body language at me to vote a certain way. So that's upholding the integrity of your process. It's a marvelous process. And but that's what I'm advising. Now let's get to the relationships with the chancellor, the staff, and presidents. First of all, the executive's role, and what the law says, what the education code says, is you should create an environment in which your CEO can succeed. So you respect the role of the chancellor or university president, is charged with carrying policy set by the board. Now, what are examples of policy? Okay, you want to open a satellite campus. Okay, that's something that it should be within the purview of the board, to open a satellite campus, or to decide to merge with another institution. That's within the purview of the board. That's a policy matter. Hiring the president or chancellor. That's probably the most important thing you will ever do as a regent or trustee, because you're saying to you're putting the future of the institution into somebody's hand, and generally a stranger. So that calls for the exercise of the highest levels of judgment, collective judgment. Thirdly, whether to sell land on an interstate. Or sell land anywhere if you have large parcels of land. That's a policy decision. But whether to change the name of the institution, that's a legislative decision ultimately, but a policy decision if the board wants to go forward with that. We had a name change in 2003 that went to the legislature and changed the name of the university immediately south of here, and that again was a board decision. What's not policy? Well, yeah, your neighbor is a dean of the College of Education, and a very obnoxious individual. You really don't like him, so what do? You go and you talk to the president and you say, well, I just don't think this person's doing a very good job. That's not for you to decide. Or even if you've met the person and he's not a neighbor and it comes and makes a presentation to the board and you think it's terrible, that's not your call. That's the president's call in the first, or the provost's call, and then the president's call. Student discipline. You're going to hear a lot about student discipline. Our regents get letters all the time about people who were upset over some discipline, or professors who weren't granted tenure. Now, these matters are vetted through the institution and through the processes of the institution and dealt with at the faculty level or at the student discipline level. And they're dealt with in accordance with process of law, with counsel watching and guiding, and folks will come and stand in front of you and tell you the most horrible things that your administrator just did. Well, maybe they're true, maybe they're not. If they're true, maybe there are other reasons why this person is being fired or being disciplined. And so you have to, at the end, it's proper to make inquiry, to ask the institution to tell you what it did and how it did it and whether it complies with the law. That's proper. But oftentimes substituting your judgment for the judgment of the president, that's something I would encourage you to avoid. If you think that the president missed something in making the decision, then you send it back and say, look at this. I want you to look at this again. Yeah, I think you may have been wrong. That's a proper exercise of the board's function. Strategies for retention that we've talked about. We had a regent, everybody said this last year, and it's really almost ludicrous. The reason you need ethics, and the only reason you need ethics, is because you have power. You have real power. Your decisions, your collective decisions, will make a serious impact in people's lives, how much money they pay for their education, what kinds of programming is available, what kinds of facilities are available. You have power. That's why you need to have an ethical construct. And people will do, you may say, we had a regent that came in one day, and bless her heart, she said to one of the administrators on a campus, gee, I really don't like what they planted outside the tennis center. I hate begonias or whatever, or maybe she loved begonias. I hate begonias. So the next time she showed up there, guess what? They planted the flower she wanted. Now, people are going, these are people that, academicians and university people are, I think, very bright people generally, but I think they are also people who are very complicit and very willing to please, and they will try to please you. One final thing I will say with respect to the board, and in particular to the coordinating board, had a regent a long time ago that felt that he was acting in the best interest or advancing higher education in the state of Texas. Well, that's not your role. That's the role that the law reserves for the Texas Higher Education Coordinating Board. And that board, the decisions that it must make. But your role, again, is to advance and protect the institutions with which you were charged. And I know that you will be very successful at that. I tell you, above all, listen to your counsel. And aside from tenured professors who may not be fired without due process, the only other employee in the institution that you must never, ever, ever fire is your general counsel.
I would like that last admonition.
I thought you would. Quick question, Fernando. You didn't touch on this, but briefly describe the role of a student regent.
Well, the role of the student regent is addressed at law. They cannot count toward a quorum and they cannot vote. They do attend executive sessions, and I was very pleased. I must commend our current regent at a board meeting earlier this month, was very actively involved at many levels in the discussion. And the student regents are there in part for helping them and creating a new generation of leaders, but they also should be actively engaged in interacting with the board and offering their opinions, the students' views, or in general, in a proper parliamentary way. And so very much encourage that, and we've been through some regents that, student regents that won't say anything, but this fellow read the materials and he knew what was in there, and so that's the proper role, to engage with your board.
Thank you. I'd like to now ask Kabi Caputo to talk with you all concerning open government issues in general. Kabi?
Thank you, Bill. So this is a topic that the elected officials, at least, have a duty to do a formal training within 90 days of being elected. This is not that formal training, so you'll get to do this again in a longer, more detailed fashion. So the concept of open government is an important one, not just in Texas, but all over the country. A case went to the Fifth Circuit not so long ago with a group of city council members suing the state, saying that the Texas Open Meetings Law violated their right to free speech. And the Fifth Circuit dealt with that case. It was involving the city of Alpine. The Fifth Circuit ruled that it does not infringe on your personal rights to free speech because it serves three important functions. The Open Meetings Law serves to promote transparency in government, which is its own good, compelling interest. It also promotes public trust in the government itself. And of course, those of you that are elected trustees, do note that your title is trustee, so there is a trust component to that. And then it also promotes fairness for the rest of the elected officials or the appointed officials. Because if you have illegal meetings going on where, the cadre of 4 or 5 who want to run everything are making all the decisions, the rest of you are frozen out of those decisions. And those 3 reasons the Fifth Circuit said were compelling enough to pose a slight imposition on your right to speak about any topic wherever you want once you get appointed or once you get elected. So let's talk about what it is that you're not allowed to do. And most importantly, you're not allowed, as Fernando mentioned, you're not allowed to take any action unless there is a properly posted agenda which the public can see. And then that agenda is going to list all the topics that are going to be discussed. But there are other things that are meetings, because the definition of meeting in the law is somewhat broader than just the formal thing that you guys do whatever day of the month or quarter you do yours. So a meeting, according to the statute, is a deliberation, which is a defined term we'll get to in a minute, of a quorum, which is a defined term, which we can get to in a minute, of a governmental body, or between a quorum of a governmental body and another person. So it's not just when you all are talking to each other and transacting business, it's when you are interacting with someone else, which is an important thing to bear in mind. A long time ago, some people had the thought that as long as we don't take action, we're not engaging in a meeting, that a meeting is where we take action. So we're free to talk about anything we want as long as it's not something we end up voting on. And that was eradicated as a concept because of some changes that we're covering here in the statute in the mid and late 90s, where they made it clear that it's not just an action-based determination of what is a meeting that has to be posted, but whenever you're receiving information or interacting with each other or other persons. So, and the definition specifically now says, or during at which you take action. So it's clear that that's an or, so that's a whole separate thing. When you take action, that is by definition a meeting. But deliberation among a quorum in and of itself is a meeting. So a quorum generally is a majority. You may have to check your own personal circumstances. You might want to talk to your counsel about that if you have questions, but I know every setting I've ever seen it, it's just a simple majority of the appointed or elected officials. And then deliberation is also defined by the legislature for us, and it means a verbal exchange during a meeting between a quorum of a governmental body or another person. So it's exactly the same thing. The definitions become circular, and I think the legislature's done that to kind of emphasize that to us. So deliberation is not just the board members or the regents talking to each other, but with a third person about public business. Arguably this meeting, and I know there's at least a quorum of one of my clients here today, this meeting theoretically is a quorum, is a meeting because a majority of you are here and you're listening to somebody talk about public business. But there's an exception that says specifically you can attend seminars and conventions and conferences in a majority of your board there, a quorum there. And it's not a meeting provided that any communications amongst you all about public business is incidental to the conference. So those of you who are here with a quorum of your boards, do not be quietly talking about public business back there. Do not be figuring out exactly what you're going to do at your next meeting. You can talk about public business as long as it relates to what we're doing up here. So There's another definition of meeting. The legislature likes giving us definitions. So another definition of meeting is a meeting at which you're responsible, or for which you're responsible, or for which you set it up, at which you receive information from a third party. So again, this notion that it's not even you talking with each other at that point, or even you talking to the third person. But if the third person is talking to you and giving you information, that too counts as a meeting. And the reason we care about this, not just because it's the law, and of course everyone should love and respect the law like we do, but you should also, care about those concerns about being transparent and being fair to each other and keeping public trust. But also, there's criminal sanctions associated with this. So you are subject to potentially up to 6 months in jail if you violate the open meetings law, or if you conspire to violate the open meetings law. And some people say, well, does that ever happen? It actually, people have never actually gone to jail, but people have been indicted, people have been charged with crimes, people have had to enter into deferred adjudication proceedings. Back in 2005, the board president of the New Diana School District up in Upshur County was indicted on conspiracy to violate the open meetings law, and here's what happened. And think about this in your context. The school board in this little school district up in Upshur County was upset with their superintendent and were trying to get rid of him. The superintendent and the board president had been talking off and on about what he would take in the way of a buyout to go away. He finally agreed on a certain set of terms. So the board president then contacted the rest of the board to say, here's what he's willing to take. Should we have a meeting to vote on that? And that's what he got indicted for, because he contacted the rest of the board to set up a meeting, which you should be able to do, because the statute says scheduling is not part of a meeting. That's a different section. But because he was telling them what the meeting was going to be about and what the terms were that the superintendent was willing to take, the grand jury indicted the individual for that. Now, the other side of the story is when they went to trial, the jury acquitted the individual, saying that the statute is so convoluted that nobody could really understand what's allowed and not allowed. But I don't want any of you to ever have to be counting on a jury to agree that the law is confusing in order to not have to go to jail and not have to pay a fine. Another reason why this is important is that action that you take at an illegal meeting can be voided. And that means it just goes away as if it never happened. And some people think, oh, that's not that big of a deal. Well, I was involved in a case down in South Texas where I represented a city that was suing another city about annexations. And we alleged that the city on the mainland had violated the open meetings law in conducting its annexations. We voided 15 of their annexations, which knocked them off Padre Island and all the way back onto the mainland. And that meant we got to recover attorney's fees. So all their annexations were voided. We were happy about that because that's what we wanted. And they had to pay $125,000 in attorney's fees. So it's not something to play around with. I don't want to sort of overemphasize, and make you terrified of anything. But you should be very vigilant about not engaging in things that are going to ultimately get not just you, but the organization itself in trouble. So other examples of legal action going on, the Austin City Council just 3 or 4 years ago. There were allegations that they were engaging in illegal communications with each other. And it turns out that during meetings, they were texting each other, they were using instant messenger on their computer system that they have up there, they were sending emails to each other. Ultimately, County Attorney David Escamilla here was prepared to prosecute them because of what they did. He investigated it for several months, got thousands of pages of documents in, and 6 members of the Austin City Council had to enter into a deferred adjudication to avoid further prosecution. So that also happened. I used to be a city council member in Cedar Park. That happened to my city when I was not on the council. I just want to be clear about that. But the same thing happened where, bad things happened, illegal meetings were alleged, and here's what happened there, and this is something to sort of put the cherry on the top of why this is concerning. The Attorney General has people in their department now that their sole job is to prosecute open government violations around the state. And in the situation involving my city council, the county attorney actually called in the Attorney General. And the same thing happened in the Upshur County case. So the Attorney General sent over one of their lawyers and team of investigators, and they're the ones that actually pursued the prosecution, not the local county attorney. So the Attorney General is very vigilant about these things. Their office is very concerned about this. Most of the changes that have occurred in the law over the last 20 years, say, have been initiated by the Attorney General's office trying to make sure that we all stay on the straight and narrow. So that's an important point there. We'll talk briefly about citizens communications. I don't know if, because I've never I guess I've never actually been to a Board of Regents meeting. I don't know if you all do citizens communications, but on the community college side, trustees love citizens communications, and everybody I know has one. And everybody reads a little thing at the beginning of the citizens communication that says, we're not allowed to interact with you or comment on what you're doing. The reason for that is because of those changes in the definitions of a meeting. Usually what somebody's there to talk about in citizens communications is not on the agenda. You know, they're there to make you aware of something, or it's an employee group complaining about something. And if it's not on the agenda, the board is not allowed to talk about it. And so the Attorney General says that they're allowed to come tell you those things, which theoretically is a meeting because it's a third party talking to you about public business, about something that's not on the agenda. But they've just sort of drawn an imaginary legal line and said, well, you know, citizens have the right to petition for redress of grievances, and citizens communication is an important part of being an elected official. So they can come talk, but you cannot respond. And that's why that little thing gets read out by your presiding officer usually at the beginning, is so that the citizens know we're not just up here ignoring you. Now, what I would admonish you to do is when that's going on, when citizens communication is occurring, look like you're paying attention. They're already upset because they don't know till they get there that no one's going to say anything to them. Many of them are terrified because they don't often go speak to elected bodies. And if they are out there speaking with their 3 minutes or 5 minutes or however long you give them, you know, trying to work through their speech, nervously shaking, and y'all are up there on your phones and, you know, clicking around the internet and things like that, it doesn't look good from a publicity perspective. So at least look concerned, nod a little bit. And then what happens at the end is, if they brought up something that's pertinent or that you think is relevant, you're allowed to say, this is one of the few things you're allowed to do in this context, you're allowed to say, I'd like to have an agenda item about that at a future meeting. And that's a good way for you to actually then communicate with the citizen that this is something we care about, and we are going to look at it, and it will come back. And nobody's violated any laws, and nobody has to go to jail. So that's how that part works. Let's see here. Closed meetings and executive sessions, as Fernando mentioned. You're allowed to go into executive session for lots of things, as he referenced. You have to convene in an open meeting first. And the things about which you're going to go into closed session have to appear on the agenda somewhere. You don't have to say exactly what you're going in there to talk about if it's personnel. You don't have to say we're going to go in there to talk about firing, you know, a tenured math professor. The Attorney General would like you to. That's been their position all along, is that more notice to the public is better. But so far, I don't know of any courts that have gone along with that. So you can just say personnel matters. Now, courts have said there are certain personnel matters that are so important, that are so of interest to the public, that you do have to be more specific. And those have been in K-12 world, superintendents and head coaches and athletic directors, and I think band directors. There's different cases where they said that's so important to the community that you need to put that there. We're going into closed session to talk about the superintendent. So that's something that may come up. The other thing that you have to be aware of in closed session is you're not allowed to vote back there. You're not allowed to go in the back, talk about it, and, you know, make everybody commit, here's how I'm going to vote when we go out. You're not allowed to have straw votes. There was a case involving the Austin School Board, you know, 2 decades ago that set that standard out for us. So no straw polls back there. What I usually recommend is, if somebody wants to know if everybody's sort of satisfied with what we've talked about, is I will often say, you know, does anybody violently disagree with this? And if you do, let's talk about it some more. But, you know, I can't ask everybody to go around the table and nod that we're all good. It's not a mafia hit where you just kind of look for the nods. And then you have to take whatever action you're going to take in open session back out with the public. So just remember those steps. You have to convene open, you can go to close, talk about it extensively, and then come back out, and that's where you take your action. Committee meetings, whether they're committees of the board itself or advisory committees that you've appointed, generally are not subject to the open meetings law. However, if it's a committee or an appointed body that you've created that actually has authority to act, the law would require you to then post those as though they were public meetings. I have a lot of clients who just generally post those things. If you got citizens advisory committees, just go ahead and post it. I mean, why not be more open than less? I often tell people we should view the law more as a floor than a ceiling. And if you want to provide more notice to the public, how is that a bad thing? But technically, you don't have to, unless, as I said, those committees or those appointed bodies get to make final decisions. There's also some murkiness about, well, what if you just always rubber stamp what they come back with? So it's best to post them. The other reason it's good to post them is if a majority of the board's going to show up at the committee meeting anyway, and I have some clients where that happens, they have a very robust committee system, but most or all of the trustees show up at every committee meeting because they all want to know what's going on. You have to post those too, because at that point it is an actual quorum of the body is there deliberating. So that is the situation with those. So I'm going to go on now and talk a little bit about open records things, and this is another area where we're going to talk a lot about, oh, that's illegal, you can't do that. And again, I'm not trying to terrify anybody, but there's been a conflict for years going on in open government world about essentially y'all's email. A lot of elected officials use their personal email to conduct their public official stuff. And the Attorney General for years took the position that if it dealt with public business, it didn't matter if it was your personal email account at your house, on your computers or your servers, to mention something that's topical these days. As long as it related to public business, it was a public record. And so the governmental body, if they receive a request from the public about things that you're doing on your personal private email account, had to produce them. Various suits were wandering around the state with elected officials saying, that's my personal stuff. Nobody gets to go into my email account and extract things out of there. And generally the courts refused and rejected that argument, saying, no, that would make a mockery out of open records, because you could just do whatever you wanted at your house, and no one would ever be able to get to it. And that does not promote transparency. It does not promote public trust in the organization. The legislature, not this past session, but back in 2013, passed a law to clarify this. And basically what they said was, it doesn't matter what the medium is in which the information is being contained or held. If it relates to public business, it's a public record. And they went on to specifically say email, text messages, internet postings. So that raises a question then. Do you text with each other about things? Do you text to your CEO about topics? Those are theoretically public records, and somehow they've got to be maintained, because not only do we have a duty to produce public records when people ask about them, but we have a duty to preserve them under a different statute, which also has, this one actually has, I think, a 2-year prison term or jail term if you intentionally destroy public information. And so the best practice, and what I always urge people to do, is if you don't already have one, get your institution to give you an official email account through their system. That way it's on their server, they're responsible for maintaining it, they can access it if people ask questions or do an open records request that would trigger that. And then there's no question about what's going on. Because if you're doing a lot of the things at home on your own computer system, all we can do at the staff level is to ask you, do you have anything responsive to this? I hope everyone here is open and honest and would say, yes, I do, here it is. But I don't have any way to check that. And so there have been cases, again, where people have said, I think there's stuff on that account, and much like, again, a topical situation about people using private email, you can find the email where it went. And when you find the email where it went and you look at the email address and it's not, whatever.edu, it's somebody's private AOL account or whatever, then people are going to come in and start digging in like ticks and wanting to see everything that's in your system. And that's something you should try to avoid at all costs. So if you don't, like I said, if you don't already have one, please get a public email account. At my city, we made it really easy. We just said place 1, place 2. We didn't even put our names on it. And that way, when I left as place 6 and somebody else came in as place 6, they got all the email that was in that server that people had sent to me and that I had sent out. Other institutions do, personalize it, and they'll put, copy.caputo at, whatever edu. However you want to structure it, or however your staff structures their protocol, is the way to do it. But that way, you're not responsible for maintaining it. You're not going to potentially be accused of crimes of destroying public information or improperly storing public information because you didn't follow everything you should have followed. So that's an important point that I can't stress enough, because it just keeps coming up all the time. The issue about text messages and instant messages, I don't even know how you save that. Yes, a question.
Does that apply to emails that people send you that you don't respond to?
Technically, yes. And so here's how I used to handle that when I was an elected official, and I've advised many clients about that. Just forward it to your public address, to your public email address. If it comes into your personal one, because they met somebody who knows you personally or whatever, just immediately forward it in. Or if you respond, forward it to your one and then respond out of the public account. That way, it's stored in the public account. But yes, theoretically, if people are sending you emails about public business and you're an appointed or elected official, then yes, you've got to preserve that too. Those are generally public. A lot of people don't know that when they email their elected officials or somebody who's, a regent, they don't always know that that is technically, probably, almost certainly going to become a public record. The only thing we usually get to redact off of that is their personal email address back. But whatever they sent you, whatever they're talking about, however you respond, those become public records in almost every case. So that's a good question, and like I said, that's the solution to that from my perspective, is just forward it into your public account. And that way it's always there. And what I would do then when I responded out of my public account, I would say, please, if you're going to email me about public business, do it at this account, not the other one. That's my private account. So text messages, and how do we preserve those? Does anybody know? I mean, we all probably have a cell phone that has text messaging on it. To one degree or another, we're all fairly fluent in it. But how do you save those? How do you get it off the phone? I've not actually solved that yet. I think there's programs. What we end up doing mostly is just taking screenshots of the text message, and we end up having to produce screenshots of people's text messages. So again, be thoughtful about what you're texting to people, because it too could become a public record. It too could be, as the Austin City Council found to their horror, because they were texting things about how stupid people were presenting to them, or, couldn't you believe how, what they'd wear? I mean, it was catty, snippy junk that they shouldn't have been doing, certainly not during a meeting. And it didn't help, their standing in the community at all, that people saw how they treat the public when they come to them based on that stuff. But, so be thoughtful before you fire off a text message to another, board member or to somebody on the staff, ripping them about something. Think, well, this could end up becoming a real document that's in the newspaper someday. So be careful about that. As I said, that has to do with anything that involves official business. The legislature was kind and defined official business for us, which is any matter over which a governmental body has any authority, administrative duties, or advisory duties. So basically, if it relates to anything involving your college or your university, it's going to be official business. And any records about that, no matter the medium in which they're maintained or that they were received, are public and need to be preserved and somehow made available for production if we ever get into a situation where somebody's asked for it. So you might want to check too, most universities and colleges have a document management set of rules. In fact, you probably have a policy that you regents or trustees have approved saying, here's our policy. But that's what you want to check on. So just to give you the criminal offense, willful destruction of public information is a misdemeanor, punishable by a fine of not less than $25 nor more than $4,000, or confinement in the county jail for not less than 3 days or more than 3 months, or both. And then there's another one under the Local Records Act that makes it a Class A misdemeanor, which is the highest level of misdemeanor before you get to felonies. And it's a fine not to exceed $4,000 or confinement in jail for up to a year, or both. So it's not 2 years. I overplayed my hand there. It's 1 year. But just bear that in mind now, that there is no such thing as, well, that's my personal stuff. If it relates to official business or public business, it is a public record. You might be able to hide it for a certain period of time. If you decide to run for president, someone's probably going to figure it out. So bear that in mind and act accordingly. And that is my time.
Thank you, Cobby. Just a couple quick questions.
Oh, no.
Let's go back to the Upshur County example for a minute.
Yeah.
The chair of the board there had worked out what sounds like a settlement agreement with the superintendent, and I see Mary coming. Let me swap by.
I'm over here now.
Had worked out a settlement agreement with the superintendent, and went ahead and notified the other board members of that settlement agreement, the terms of it.
The terms, yeah.
And asked whether or not we should get together for a meeting to deliberate on that settlement. Got indicted for violating the Open Meetings Act. What could that board chair have done to avoided any indictment for the Open Meetings Act and still accomplished the same end?
You know, the best I can figure out is to have just told them, I've been meeting with the superintendent, he's given me the terms he's willing to accept, I'm going to call a meeting to discuss that with the whole board. What days are you available? You know, make it strictly about scheduling and not substantive about what was discussed or negotiated.
And then post it as an
Yeah.
open meeting.
And do it properly
And you would name the superintendent
in this world, in K-12
because
world,
of the prior case law that you mentioned.
yeah.
As part of the posting, you'd go into an open session, and 1 or 2 minutes later, you're in a closed session to deliberate the continuing employment of the superintendent and perhaps the terms of any
Right.
separation.
Yeah, at that point, you can have, as one of my friends like to say, a full-throated conversation about the terms that he's willing to accept.
One other quick question, and this has come up from time to time, I get calls on this, where somebody's IT department says every week or every month, delete all your emails.
Yeah.
We don't have that kind of storage capacity. What do you think of that kind of
The-
IT advice?
That is not in compliance with the law. It's a challenge because IT departments then say, well, we need all this money. What I've asked, because that's happened to me in at least 2 different cases with large organizations that should have known better. I tell them, I'll write you a memo that will threaten everybody with going to jail if you persist in that. So they've got to store the stuff. What they can do is go through and pull out everything that is not relevant. You know, if I'm sending you an email about, hey, do you want to go to lunch? That doesn't have to be stored for any meaningful period of time. But who's really going to hire the staff necessary to go through, however large your organization is, thousands of employees, emailing each other about where you're going this weekend, or did you see this funny cat video? All those things don't have to be stored. But it's more cost prohibitive to go about deleting those things in an ordinary course than just say, we just save everything, and it's all in the back in a giant server that's doing nothing but storing things. And that's what you end up having to do, and these IT departments need to, I mean, I had one that even said, well, we don't have to keep emails. Well, I mean, it was clear before the legislature changed things in 2013, it's crystal clear now. Emails, if they relate to public business, need to be run through the process, and it's a complicated document management process. And again, that's why everybody just says, just buy teraflops of storage space and everything just gets dumped in there. So yes, they're not allowed to auto-delete things. I had a school district client that used to do that. We'd get open records requests, and it was a superintendent. And I would say, what do you have on this? He says, oh, I delete all my emails at the end of the day. I was like, God. Literally, he had no emails by the end of the day. And because they were on a standalone system, they didn't even have a centralized email system. So that was the only place that the emails existed. So you can get into the games of the forensics type stuff of trying to recover the deleted emails off the hard drive and things like that. It is such a difficult situation to deal with and such a hassle. You know, storage isn't that expensive, really. I mean, I had one client that was saying this, that they didn't have the budget for it. And I said, what do you need? And he said $950,000 or something. And I said, your organization has an annual operating budget of $300 million. Are you telling me we can't find $900,000 in that budget to comply with the law? And within, you know, the next budget cycle, they had their $900,000 and they had the storage and the system is running the way it should. But it should not be that difficult. It's just everybody has to be more aware of what the law requires.
Thank you. What we're going to do next is we typically have a third attorney on this panel in addition to Kabi and Fernando. And that third attorney typically has been Donna Cornell. Donna is the general counsel of the University of Houston system, and she had planned on being here this year. However, her board had to reschedule a meeting for this week, and so she has that meeting today, and it's a direct conflict, and so as a result, she could not be here. So what we do have, however, is a video, a short video of Donna Cornell making a presentation relating to ethics and conflicts of interest And then we're going to have a series of PowerPoint slides for an interactive experience with the audience and with Fernando and with Kabi, myself. And so with that, I'm going to turn it over to this gentleman to start the video.
I've got some slides for you. We're going to go through some case studies. But I wanted to talk to you a little bit first about ethics and conflict of interest in general. You know, a board is obligated to stand for ethical behavior. What does that mean for all of you? Really, it's doing the right thing, following the law, following the rules, understanding your governance structure, doing the right thing, giving everybody an equal chance. How does that manifest itself in your day-to-day work as regents and trustees? One thing is you should all present and insist the people that are under your control, your chancellor and senior management, under that chancellor or president, depending on the case, exhibit the appropriate behaviors. But you all have to exhibit those same appropriate behaviors. Again, doing the right thing, ethical behavior. Many of you, we do in our board, require our regents to sign a code of conduct where they actually sign our board adopted under one of my previous chairs, who's sitting here, a requirement that the regents sign that code of conduct every year so that they look at it, aware of it, and take responsibility for it on an annual basis. I really think that's good practice. It's not required by law, but certainly best practice sets the tone. The tone is always set at the top. You all know that from your private businesses. So I would encourage you all to have those codes of conduct. It's going to cover things like conflict of interest, relationships with vendors, privacy, confidential information. You will get lots of confidential information and how that is used and not used. It should cover things like, or can cover things like discrimination, sexual harassment. That's a big issue. I know you all may be discussing, I don't know, Title IX, which I know has been in the media tremendously and should be something on your radar. Those kinds of things I would expect to see in your code of conduct. And gifts and acceptance of gifts and what are the standards for that, which is something we will talk about. Code of conduct, channels for people, another best practice, code of conduct, channels for people to bring forward to you or to administration, questions and concerns. Do you have a process in place? An anonymous reporting system many institutions use. There are different ways to do that, not one set standard, but it's one of those best practices, ethical conduct. Many of you see it in the private sector after some of the traumas in our public world after Sarbanes-Oxley got it adopted. That will be part of your day-to-day business. It has not been part of day-to-day business in public setting, but it's something that we have implemented at many institutions, including mine. So we have an avenue for people to come forward and complain. We have a hotline. We make sure that those things are not just brought forward, but investigated, and then we close the loop at the end. Sometimes you will find that the investigation occurs, everybody knows, maybe in some cases something is happening that shouldn't, but has the loop actually been closed? So that's, part of our best practices, tone from the top, best conduct, and have training. This is an example of the training. Ensure that I actually sit down with our board right after they become sworn in and provide them some training. That's something I would hope that you all get as well. So those are kind of like the best practices in terms of setting what I consider to be the tone from the top and good behavior, doing the right thing. The Texas legislature has kind of been much more prescriptive and not as general with regard to conflicts of interest. They're on one of the sheets that Fernando gave you. The conflicts of interest section, it comes from the Texas Government Code, talks about gifts and bribes, your professional and business activities. This is on the document duties and ethics of public sector board members on the second page. Employment, investments, so we'll talk a little bit about those. A board member cannot have their personal private dealings interfere with or pose a conflict as it relates to your duty of loyalty to your institution. So your personal business, you have to keep separate. If there is a transaction that would have a personal interest in, you need to step back, step out of the room, and disclose that to your fellow board members. It's not that the proceeding cannot go forward, it can go forward, but you must disclose a personal interest or conflict in the specific transaction. The conflict of interest and business dealings, these issues that the Texas legislature has set out, is only, to me, one section of kind of the two main areas of risk or focus from the state law standpoint. The other one relates to gifts, and those are kind of what I consider the should-nots. We don't take bribes. Well, that's kind of a no-brainer. Everybody kind of understands that. It's set out in the penal code. Yes, those things all apply to you. But how could it catch you short, even unintentionally? And so that's one reason why I wanted to have some of these case studies for you today. There are exceptions, and those things are going to be the types of situations you typically find yourself in, where somebody is, buying you a lunch, and it's fairly, you're at, where would we go to lunch? Sonic, or at the hotel here. Your bill is probably going to be less than $50 a person. The Texas legislature has kind of set out $50 as kind of a guideline for things that are not considered actual gifts. There are times, and I would encourage you to ask your counsel about specific gifts so you can get that specific piece of advice when you are in doubt, because there are a lot of exceptions that can come into play that exceed the $50 threshold. The $50 threshold is just a bright line that makes it easy for you, but if it's over that amount, there are exceptions that would be allowed. Especially, you will find yourselves, for any of you that are involved in helping your institutions in philanthropic activities, where you will be with a donor or a potential donor, and there will be an exchange or a sharing of a meal or going someplace, and the bright line is not $50 in those situations. So I would encourage you to have those conversations, because they are very specific. The other types of gifts that can be permissible can, in fact, raise an appearance of impropriety. This is one of those things where it may not be illegal, but it will look bad. So even though I'm going to advise my board what is the strict standard, I want you to also remember there is also the appearance of impropriety. And those are the kinds of things that can be more damaging to your institution than even following the strict bright line rule and law. And oftentimes those are unsolicited, be unsolicited gifts, maybe not something you want to accept. What do you do in that situation? Or maybe you do accept them in perfect innocence, the Association of Governing Boards, which has set out a pamphlet on conflicts of interest, and they set out their best practice and their standard for conflict of interest. And it reads as follows: if reasonable observers having knowledge of relevant circumstances believes there's an actual or apparent conflict of interest, the board member shouldn't participate in acting on that transaction. Now that follows our statute. Their statement goes on, and this is why I wanted to bring it to your attention in case somebody starts talking to you about this. They go on and they say, well, if there's a compelling benefit, if there is a real advantage to the institution, then maybe you could still, that trustee or regent or board member could still participate in the transaction. Well, that would be contrary to state law. So that would be an exception that wouldn't be applicable for us. And even though it's set forth as best practice, I think it follows more of the traditional private sector standard for conflicts of interest, is not one that I would recommend in the state or public context.
One thing that Donna mentioned about meals being an exception and travel also potentially being an exception, this last session, the legislature changed that, and you can no longer travel with someone or go into an event with someone in more than $50 increments. They can still buy you food that costs more than $50, but that's the only one that was left over in the most recent legislative session. There's a question. We're waiting for a microphone to get to you. Wait.
Okay, you got it. Thanks.
About that.
Anyone, engineers, lawyers, architects, contractors.
My law partner?
Are they taking you to dinner because they want to be the lawyers for your organization or something like that? Then no.
No,
That's fine.
that's the point I'm trying to make.
Yeah.
Because I don't think y'all have made that clear. You're talking about people trying to do peer business with the university.
Yeah.
You're not talking about people in general,
No.
friends.
No,
who
that's-
can
that's
buy
correct.
You a meal. Y'all didn't make that clear. That's
Yeah.
what I was.
Yeah, I was just making the point that it used to be that they could take you to the Dallas Cowboys or they could, take you to the Final Four, and that was allowed as long as they were with you, and that's no longer allowed. Only meals are still allowed. And yes, it has to be someone who's, making a gift to you because of your position as a public official.
And the other piece to that is that if the gift is one that would reasonably induce you to violate your position, the requirements of your position, or if it is given with the intent to influence you in the discharge of your duties as a public official.
Which you will know in your gut.
Yes.
A coffee cup is not, but there may be situations where what might be otherwise a nominal gift, if it's intended to influence you, and you know it's intended to influence you, that makes a big difference.
Yes, ma'am.
For Mr. Caputo, you didn't mention anything about text messaging and/or recording during executive session?
There isn't any law about that. It's something that makes a lot of people uncomfortable. I've actually been a member of a city council where someone's constantly text messaging, and ultimately we froze him out. We told him if he kept it up, we weren't going to have executive sessions anymore. We didn't know who he was texting with. We didn't know what he was talking about, but it made enough of us nervous that the elected officials had to, the staff can't do it. The elected officials had to take the stand and say, we're in here doing confidential stuff. It needs to stay confidential, particularly legal advice. You waive the attorney-client privilege potentially if it's publicized, but there isn't a statute that says when you're in executive session, no one can email or text or whatever. They shouldn't. But yes, we can't point to a law and say you're breaking a law.
And be aware of, if you're in executive session under attorney-client privilege, there's no need to either record it or keep notes of it. However, if you're in executive session for any other reason, either a recording needs to be made or somebody needs to be taking notes, and then those notes need to be typed up and retained for at least 2 years, or if litigation comes about as a result of action taken during that executive session and afterwards in open meeting, then the notes or the recording will need to be kept through the end of the period of the litigation. So just be
good point.
aware of that. You don't want to be caught in an executive session talking about personnel, for example, and not have either a note taker or a recording. What we're going to do now is move into, whoops, another question.
You provoked a question.
If there is a professional that currently does business with your institution and that relationship existed long before my appointment, and this professional was a personal friend of mine, we travel together, we hunt together, we fish together, and now that he is in the position of doing business and was before and will continue doing business with the institution, do I have to just throw him overboard and say, I'm sorry, I can't talk to you or see you or be around you anymore the rest of your life?
Well, we like to talk in hypotheticals here. I always tell I teach a couple of classes, and I always tell my students that. I'm not here to give legal advice to anybody, but we can talk hypothetically about things that may have happened to you or your friends. It's a hard question. The law does have an exception about you can still receive gifts from personal friends. You have to start looking at the appearance of impropriety, perhaps, as the driver there, more so than the strict letter of the law. And I'll certainly defer to Fernando on this, but, you know, a lifelong friend, you know, doing lots of things together, it may be best during the course of the appointment to the position or the elected office to, you know, not stop doing it, but make sure you're paying your share of it or something like that.
It is a very slippery slope
Yeah.
because as one of our regents, our former chair, pointed out one time, what they have in common, essentially, they come from different walks of life, what they have in common is the board. And yes, friendships are formed, and some of those friendships may be very enduring, but as long as there's a professional relationship, I think you err on the side of avoidance of the conflict or the appearance of the conflict.
So your advice is to throw the guy overboard and say, I can never talk to you or be seen with you again.
No.
No.
No, that's not what I'm saying at all. It's, you know, you can retain the friendship. It's just that where it becomes confusing with respect to a gift. For example, let me take a personal situation. I had a board chairman years ago that I tried a case with when I was not with the Texas State University system. We were fortunate to be successful, and he was on a board that hired me, and we worked together for several years. Marvelous, marvelous man. He left the board. One day, out of the blue, he sent a $100 gift certificate for Fleming's Steakhouse. I didn't want to send it back because I thought that would not be well received, and he felt that he was a friend and he was doing this for a friend. What I did is I just kept it in the file and never used it. I thought that protected him and it protected me as well. Now, since he was off the board, could I likely consider him a friend? Yes. But again, you retain the friendship, but you don't necessarily need to take the gift. If friendship is contingent on the gift, it's really not a friendship. And so I always advise to err on the side of the ethical side of things, because there is an appearance of impropriety. You are in the public eye. And as I said earlier, part of why we have these ethical constructs, which are very, very difficult to enforce, because it's something that the law is trying to define for the first time personal relationships. The British parliamentarian in the 1800s who said that ethics was adherence to the unenforceable. Well, the Texas legislature has taken these concepts of right and wrong that are common to a people and tried to put them into a statute or a set of statutes. And it doesn't quite fit as easily, because I think, as your question very well exemplifies, there are human relationships that sometimes get in the way of those statutes, or vice versa. So I hope that that addresses it, but I understand what you're saying. I think we all do.
I'll call him tomorrow, thank you.
Okay.
Ramona,
Thank you.
go ahead.
In the same vein as having the law be a floor and not a ceiling, I'd like for someone to revisit the executive session minute-taking or note-taking or recording piece. I thought I heard today, sometimes you may record something in executive session and sometimes you may not. But using the standard we just talked about, why wouldn't you do it at all times? So can someone respond to that?
The statute does say that you either have to keep a recording or a certified agenda, which is the notes that Bill was speaking about. Different organizations handle it different ways. The other thing that Bill mentioned was that when you're consulting with your attorney, you don't have to keep either. And that's something that some lawyers are very forceful about that. If they come into the room and there's a recorder going, they're like, turn that off, we don't have to do this. Others are, we'll just talk about it. It's really an institutional decision about, what you want to maintain. They do get destroyed after 2 years, so it's not like, 50 years from now somebody's going to find the secret history of the organization. But I've been involved in cases where the closed sessions were recorded and then they were made to be disclosed, and very bad things happened to everybody because exactly what was said back there became either useful in a lawsuit or a matter of public record. So some people prefer not to do the recordings because they would rather not have a verbatim transcription of what people are talking about.
And the note-taking can be relatively cryptic. It's essentially an outline that touches on the high points
Yeah.
of the executive session, as opposed to a recording which, by definition, records what every individual in that room says.
It is easier to maintain the certified agenda because, as some of you know, at times recorders run out of batteries, or it turns out recorders weren't working. My city actually had that. We had almost a year and a half of doing something where we didn't realize that the recorder in the closed session didn't work because nobody listened to it ever. And somebody finally went and listened to one and said, hey, there's nothing on there. And we did investigate, and it turns out for close to 2 years, we didn't have any evidence of what was going on because we were inept at operating the recording equipment, it turns out.
And the
So-
reason I brought up the idea about the certified agenda or note-taking or recording during executive session, except in the event of attorney-client privilege discussions, is because if you are aware that a recording is not taking place, nor is any note-taking taking place, so that there could not be a certified agenda, it is indeed a misdemeanor
Yeah.
to participate in that executive session if you have that knowledge during the session. Now, in the example Kabi just gave, obviously that would not result in a misdemeanor charge because
It did not.
they were totally unaware that the recording device didn't work. But I think we've got another question over here.
Well, twofold and a comment, because I was recently, well, in my previous board service, when we went into executive session, if we were talking with counsel, it was talking with counsel only, and we used a certified agenda for the other items that were authorized in executive session. But my question would be, if you were going to record it, why don't you just do it in public? Because that's what it's going to become if you record it. So to me, recording it makes it lessens the impact of having an executive session, because executive session is where you're supposed to, on one hand, be able to let your hair down a little bit, get into a little bit more nitty-gritty, and then move the group to wherever, I guess you'd say, that they have the information, and then you go back out in open meeting and move on from there. So does not that, while it's authorized, does it not on one hand defeat the purpose of going into executive session?
Well, arguably, if there's a recording being made, and I've had board members say this to me, there would not be as free-flowing a discussion as there would otherwise be if basically one person was taking notes. So that's up to each board to make their own decision, however, as to what approach they wish to use.
I'll tell you one thing that is useful about having a recording, and there are circumstances, as I said, I've been involved with them, where the recordings do come out. It's relatively rare. I mean, it's happened to me twice in 28 years of practice. So Other trustees who, for instance, missed the meeting can go listen to the executive session and get up to speed a lot better than they could if they just see a certified agenda that said, you know, we talked about some real estate, we talked about a personnel matter, and we talked about a gift. That's not going to give them much insight as to what happened, but if they can go in and sit down in a, you know, secure area and listen to the recording, then they know exactly what happened and they're up to speed at the next meeting. So, as Bill said, it's really an organizational decision. Since I'm an outside person, I tend not to push organizations to go one way or the other. If they've recorded things since time immemorial, I'm happy to continue with that. If they've never used the recording, you know, I don't try to force them to go to the recordings. It's you know, their culture, their organization, so.
Yes, ma'am.
The changes to Government Code 176 on disclosure of the conflicts or the gifts and those kinds of things, I think you're referring to earlier. So hypothetically,
Yes.
Company X periodically will sponsor the table at the chamber luncheon, or maybe the Heart Association gala, or whatever. So there's obviously a threshold difference of the cost of that ticket, maybe from one to another. And Company X then periodically might bid on, you know, on engineering work or banking work, or represent somebody in front of us who's looking for a tax abatement or something like that. So with the changes in 176, both the vendor and the institution or the regent has to disclose that. Can you talk about that threshold, and can you give us some hypothetical guidance? Is there a per event dollar amount? Does the company disclose, we disclose? Can we talk a little bit more about that?
Yeah, it's kind of a, you know, this is a fairly new statute, so we don't have a case law to fall back on. But, you know, if it's an event where there's a meal, then, you know, you characterize it as a meal. And there's no dollar limit on a meal as long as they're present. Now, if they're not at the table, then everybody should probably get up and leave. But if it's, you know, going to some event or something like that, then that needs to be disclosed, and really nobody should be doing it. If it's more than a $50 entry ticket.
A gala kind of event, it's a $200 ticket?
Is there a meal involved?
Yes.
Then I would say you attended the gala event and had a meal. Okay. But you'll probably want to talk to your own counsel about that, and I'm sure the lawyers all want to, you know, ponder it a little more and contemplate. But we had a situation in my city council where we negotiated a deal with the Dallas Stars to bring a hockey team to Cedar Park. And at the meeting at which we approved the final agreement, they brought down Dallas Stars hockey jerseys with all of our names on them in the back. So we were all wearing the jerseys as the mayor signed. We had a very nice picture with a bunch of hockey players. And well, it turns out those jerseys cost $300. We didn't know it. So our city attorney found that out and made us all return the jerseys to him. And what you can do if you do receive a gift that's more than the threshold amount is you can donate it to a public institution or a charity. So in that situation, we donated our jerseys to the city, and I never saw it again. I don't know what happened to it, but it was right there on the front page of the Statesman, you know, so nobody could really deny that it happened or that we were wearing the jerseys, so it was an awkward situation. There's another question.
Another question.
We're not going to get to the.
My question goes back to the public forum or citizens forum
Yeah.
position, portion of the meeting. If you have a student complaint process, an employee complaint process, and a public complaint process where you have the opportunity to resolve the problem at the lowest level, can you prevent someone from complaining, someone in the public from complaining in the public forum?
That comes up occasionally, and I know like the TASB standard policy for K-12s and community colleges says that the presiding officer should cut them off if they start talking about specific people in personnel matters and direct them to use that process. It's kind of more of an art than a science as to where you let them have their Article 1, Section 27 right to, you know, complain versus driving them into a specific process. So the general rule we try to train people on is if it's a general complaint or a general discussion and they're going to get 3 minutes, you let them have it. If they're going to get very specific about people or specific incidents and events, then the presiding officer is allowed, and there's actually at least one case from the Fifth Circuit where they said that this is legal to tell them, you know, you can't talk about that here, there's a process you need to go through for that. It's an awkward situation. I don't know any presiding officer that likes having to stop the public from saying things. And honestly, in my experience at, you know, hundreds of board meetings all over the state, most of them just let it go. Most of them don't want to be the person that cut off a citizen's right to complain about something. At the end of it, they may say, you know, thank you for bringing that forward. We have a process that you need to go through, and that'll be the resolution of it. But you could be more forceful than that and just say, because you're talking about specific people, please get with the administration tomorrow. There's a form you need to use, and there's a process you go through.
Is there
Not a great
another
answer.
question over on this side
Yes.
of the room?
Under what circumstances is a board required to disclose either the tape or the certified agenda of an executive session?
By law, go ahead. No, you go ahead.
If a court orders the board to disclose it, it would be the situation that you're describing. Oftentimes what can happen, and these rarely arise. Let me preface my remarks by that. But in the event it does, the court may well listen to it in what's called in camera. In other words, the court will take it to its office, and if you've got a recording, listen to the recording. If you've got a certified agenda, the court will take a look at the certified agenda. It may or may not, based on the facts of that case, pending in front of it, make a decision on whether or not the agenda is to be disclosed or the recording is to be disclosed.
It will generally be if there's an allegation that the open meetings law was violated, that there were things discussed in the closed session that were not posted. That's the context that I've seen it successfully happen, where then it becomes a public matter. We've exhausted the questions. That's
Okay,
good.
we've got a few slides that I think we should at least take a crack at. We don't have much time left, but here are some examples of ethics and conflict situations that we can kind of sink our teeth into. You get a call from a friend asking you to intervene on behalf of his daughter, who is seeking admission to the university on which you sit on the board, and she's trying to get in as an undergraduate, but may not have the qualifications to get admitted. What do you tell your friend? Tough question. Happens. Happens with some regularity.
As it turns out,
Well,
I will say it doesn't happen often in the community college world, so this is more of a four-year concern.
should you sign a letter of recommendation on Regents stationery? No, probably not a good idea. What about a letter of recommendation on your personal stationery? Well, if you've known this girl for much of her life, you've known her family for years and years, that's probably permissible. I mean, you're a friend of their family. Simply because you hold a spot as a regent doesn't mean you give up your rights as a citizen. By the same token, be careful about creating a potential appearance of impropriety. What you can always tell your friend is, here's the people at the university who are making decisions on admission. You may want to get with them. And when we talk, and all three of us have talked about appearances of impropriety, picture the front page of the Statesman as where the story could result. Fernando?
Yeah, I would also make a call, probably to the president, and make sure that the people who are looking at the application understand that they should remember begonias. And by that I mean, because you are a regent, because of the authority or the power that you have over the president and others within that institution, I think it would serve you well to pick up the phone and say, look, I've known this person all of her life. I'm not going to talk about whether you should admit her or not admit her. That's your decision. I just wanted you to know about her character, her qualities as a person, and whatever you do is going to be fine with me. There will be no repercussions. And then that way, at least, everybody understands that whatever you know, that you really are writing as a friend. You're not asking for a favor.
Next example is you're approached by an alumnus who is also an architect, and he wants your help in helping him land a major university building project. What do? I think what I would recommend in that situation is let your alum know what the process is, who the people are that will likely be involved in that process and perhaps make the ultimate decision. I would shy away from intervening, either by telephone or by letter.
Or text message.
Or text message. And the same thing would apply to the next question about the local service vendor.
And keep in mind that at least with respect to state agencies, if you're going to sole source contracts under Senate Bill 20 that just passed the legislature, you're going to have to post on your internet website that you did it and why you did it and the reasons why you did it. So there are some implications to whatever those actions may be that you take.
Next hypothetical is you're invited by the president of one of the campuses in your system of schools to visit that campus and meet with folks interested in donating land for the campus. What's your proper role? Anybody? I would suggest go ahead and do it. Absolutely. To me, that's a component of a regent's role or a trustee's role.
And the only kicker here, I very much agree with Bill, is if the president reports to a chancellor, I'd let the chancellor know.
Well,
But that's what you're there for, to interpret. The statute says, the education code says, to interpret the campus to the community to the campus. You're to create a situation for the CEO in which he or she can be successful. This is the essence of being a trustee or regent, as Bill says.
next one, and probably the last one, given the time, you get a call from the governor's office insisting that you vote against any tuition increase because the governor is concerned that it will hurt his reelection bid.
This is another hypothetical.
This is most definitely a hypothetical and likely would never happen. And remember, these are Donna Cornell's hypotheticals.
That's right. Donna Cornell,
That's
University
Donna.
of Houston.
Throw Donna under the bus.
Anybody? Let me suggest that, as Fernando mentioned early on in his presentation, you need to be respectful to the governor, obviously. The governor's the one person who put you on the board. But you have to evaluate the entire situation and make your best decision based on all the facts. And primary among all of those, as Fernando pointed out, as I said early on in his presentation, is you have a duty of loyalty first and foremost to the institution of higher education that you represent. And with that, I want to thank you all. We'll be around in case anybody else has questions for at least a little while after this, and good luck with the rest of your conference.